So a very warm welcome to you all this evening. We are delighted to see so many of you joining the session today. The Nuts and Bolts series is always extremely popular and provides a very good opportunity for practitioners to refresh their knowledge base in relation to our core practice areas. Tonight's event, as I said, is hybrid, so we have attendance both in person, in the room, which is very refreshing, and online, and I very much hope and expect that you'll find the presentations and discussion to be useful and informative. My name is Myriam Stacey, KC, and I'm extremely happy to be chairing tonight's session. I'm joined by my colleagues to my right. Kate Traynor joined Landmark in December 2021. She practices across Chamber's main practice areas with a focus on property law. She regularly acts for landlords and tenants in all types of residential and commercial property matters, and her work, fittingly for tonight's purposes, regularly covers service charge matters. By way of example, she recently worked on preparing submissions before the FTT on behalf of a landlord in a service charge matter, as a result of which the tenant's application was dismissed. And she will be talking to us tonight first about contractual machinery and valid demands. Next is Peter. Peter Sibley joined Chambers as a tenant in October 2021, and since then he's been busy building his successful practice with a strong focus on property law, both residential and commercial, and including service charge disputes. He regularly appears in the county court for hearings and trials, has appeared before the FTT, and also in insolvency and companies court. And in terms of other areas of specialism, he also has a particular interest in rating and insolvency work. He will be talking to us tonight on the topic of service charge consultation requirements, very tricky area. And finally, Admas, 2014 call. He specialises too in property litigation, and he appears very regularly in the High Court in both divisions, County Court and tribunals in a wide variety of property disputes. He has particular expertise in landlord and tenant matters, and his cases often raise cross-cutting public law and human rights issues. He's also regularly led in heavyweight appellate and trial litigations, and amongst other things is currently instructed in a 4-week trial in the Chancery Division concerning a dispute regarding rights of way over the largest brownfield development site in Europe. He will be talking to us tonight about applications under the very important Section 27A of the Landlord and Tenant of the 1985 Act. So without further ado, I will now hand over to Kate for the first presentation.
Thank you.
Thank you, Kate.
So, in terms of the starting point for any sort of topic and discussion about service charge, you need to look at the contractual machinery and the construction of the lease, and importantly, the decision of Arnold and Britton. So in this particular case, the court rejected the submission that service charge clauses are to be construed restrictively and should not be construed in the absence of clear wording, so as to entitle the landlord to profit over and above his actual outlay in providing the contracted services. And in this decision, there were several helpful observations, to which I refer to a few in the presentation and just outline a couple more. So essentially, when looking at the interpretation of contractual provisions and the construction of the lease, you need to identify the intention of the parties by reference to what a reasonable person with all the background knowledge would understand, save in exceptional circumstances. That meaning is the most obvious meaning gleaned from reading the language of the provisions. You then need to focus on the surrounding circumstances and the commercial sense of the agreement, but it should not be invoked to undervalue the language of the lease provisions and what they are chosen by the parties. With that, the court should not actively seek ambiguities or lack of clarity in order to justify departing from the natural and ordinary meaning of the lease provisions. Commercial sense is only relevant to the extent how matters would or could have been perceived by the parties at the time in which the agreement was made. And in essence, Arnold and Britton reminded a lot of contract lawyers of the primary importance of the contractual words used when drafting the lease provisions and the agreement between the parties, and reminded them that the surrounding circumstances and knowledge of the parties at the time of the contract would only be relevant as tools to interpret what the language would have meant at that time. So the next thing to look at is the service charge demands in and of themselves. So the starting point is when you're preparing a service charge demand is to have in mind that there is a possibility that at some point the court might be scrutinising what you've put in that service charge demand in order to determine its validity. The case of Yorkbrook essentially set out that the landlord's repairing covenants were to be subject to the tenant paying the service charge. And what the Court of Appeal held was that as a matter of construction, the meaning of subject to was not a condition precedent to the landlord's repairing obligation for the tenant to pay the service charges. They went on to say that unless on true construction of the lease, payment by the tenant of the service charges is a condition precedent to the landlord's repairing covenant, then non-payment of the service charges would really provide a defence to the tenant's claim for damages for breach of covenant by the landlord to provide those services. The next element of the contractual machinery to look at is whether or not there's an entitlement for interim payments on account. When looking at that, you need to look at the right to demand an interim payment on account and whether that's expressly provided for within the terms of the lease. In the absence of any express right to an interim payment, the courts will not readily imply any such right into the contract. The lease may set out very specific steps which must then be undertaken by either the landlord or their management agent before interim service charges can fall due. This might be, for example, that the landlord is only entitled to make an interim payment or an interim demand following a computation of the estimated costs of repair, which need to be certified by a surveyor or accountant. Failure to comply with those contractual provisions will render any interim service charge demands invalid. The next element of the contractual machinery to look at is whether or not time is of the essence. And by that what I mean is, in common law, unless the lease specifies otherwise, the time is not of the essence in the preparation of the landlord's service charge accounts for any particular accounting period. The usual issue is where the lease provides, for example, an account to be prepared within X amount of months at the end of each accounting period. But the case law suggests that such provisions still do not make time of the essence. What I will come to touch upon is, so far as residential leases are concerned, is there is an issue about an 18-month period under Section 20B. And essentially that is that costs are not recoverable if they're incurred more than 18 months before the demand. But later in this presentation I will go into that in a bit more detail. The next element then of contractual machinery to look at is there certification and demands. So in lease agreements, it's common for it to be provided that for the service charges to be recoverable by the landlord for any given accounting period, they need to be determined or certified by an accountant or surveyor. In such circumstances, the issue of a valid certificate complying with the lease provisions will usually then be a condition precedent to the obligation to pay the service charges. So what that means is you'll have to have those accounts certified by the surveyor or accountant before you can make a valid demand for service charges. If you don't have that, then your demand may be invalid. So the consequences of failing to comply with certification of accounts or demands is that the charges will not be due. The other point to consider under certification is whether or not it's conclusive or binding. And by that I mean is where a certificate is not conclusive or binding on the parties as to the matter set out in that certificate, then they can be challenged. So if the provision doesn't say that they need to be certified by an accountant or surveyor for them to be conclusive and binding, you could then still challenge these before the courts or the tribunals. It is common though for a lease to provide that the certificate of accounts will be final or conclusive. Even if it does say that, it's important to note that in residential situations, that kind of provision does not oust the jurisdiction of the court or tribunal to determine whether or not the service charges are reasonable or payable. So even if that is there, it's not a defence to say, well, it's conclusive or binding. The courts and tribunal will retain that right to allow a tenant to challenge those service charges if they consider them unreasonable. The next element to look at is the demands themselves and whether or not the demands are compliant with both the statutory requirements and the contractual requirements. It's important, and one of the biggest mistakes that people tend to make is the compliance with Section 47. And what this provides is that a demand for rent or any other sum payable under the lease or tenancy must include the name and address of the landlord. If that address is not in England and Wales, an address in England and Wales where notices can be served on that landlord. If the landlord fails to comply with Section 47, then the tenant is not liable to pay the service charges or administration charges until such time the landlord complies with Section 47. So in terms of this, it's a suspensory provision, and by that I mean is it's suspended for a moment in time, but if you later comply with Section 47, then your demand would be validated. The other points are to consider in terms of Section 47 is the fundamental purpose of this provision is to know who your landlord is. It's to inform the tenant that this is the person who is your landlord, who you can serve your notices upon. The requirement to provide the landlord's address is not satisfied by providing the management agent's address. It must be the landlord's address. Corporate landlords should provide their registered office or the place where they carry on business. And if the landlord is a private individual, then it must be their residential address or the place in which they carry on business. Where the demand contains more than one name and address, it's necessary to identify who those parties are. So you'll find that in a lot of lease provisions, you have a landlord and a management agent who deals with the demands. With these demands, you have to specify this as the landlord, and then the other address is normally the management agents. It just needs to be clear who is who. And that's because the leaseholder isn't there to guess who their landlord is. As I mentioned, it's a suspensory provision only. So what that means is the service charge or administration charge is treated as not being due at any time before the information is furnished. But once it is furnished, then it validates the demand. Another point to note in terms of practice and when you're in proceedings, it's generally inappropriate for the tribunal to raise this point themselves if the tenant hasn't raised it. So it's not for the tribunal to say, well, your demand isn't valid under Section 47. It's for the tenant to raise that point. And if they haven't raised that point, then the tribunal can't make a determination on that. So the next point that we come to is Section 48, and this tends to be a bit more of an issue than compliance with Section 47. And this is because it requires that any landlord must supply a tenant with an address in England and Wales where notices and proceedings can be served on the landlord. If this isn't done, then the rent is not due until such time as it is supplied, and the effect is that the landlord would be prevented from enforcing recovery of any rental charges. Importantly, there's no specific art to giving a Section 48 notice. It's not like Section 8 or Section 21 notices. And what that means is there's no specific form. It's satisfied if the tenant is given the information in writing, but that's all that is required, is it needs to be in writing. It's not a specific form that you can download. A lot of the time it's simply a letter setting it out with the relevant information included. The next point to consider is the time limit for making demands. So under Section 20B of the Landlord and Tenant Act 1985, service charges must be demanded within 18 months of being incurred. And it's important that a demand for charges is issued within that time to avoid them becoming time barred for recovery. If, however, you don't make the formal demand within 18 months, all is not lost if, under Section 20B(2), the landlord has served written notice within the 18-month period that they will be incurring costs and that subsequent service charge demands would follow. Then those costs would be recoverable. So how we look at this is essentially Section 20B1 imposes a limitation on the recovery of service charges from long leaseholders of residential premises, so that the costs aren't recoverable if they were incurred more than 18 months ago. But if you've been a sensible landlord and sent out a letter advising the tenant that these future charges will be demanded by service charge, then you would be able to recover those under the provisions, provided you do so in 18 months. Finally, the next thing to consider is the summary of rights and obligations. So, pursuant to Section 21B of the Landlord and Tenant Act, since October 2007 in England and Wales, and the 30th of November 2007 in Wales, any demand for the payment of service charges needs to be accompanied by a summary of the rights and obligations. Again, it's suspensory in nature. If you then later comply with it and provide that information, the demand can be validated. But if you fail to comply with it, then the tenant's not liable to pay the service charges until such time you can comply. And a tip to note with that is that there's one set of rights and obligations for service charge demands and a separate set of rights and obligations for administration charges. So to avoid including the wrong one, it's best practice to print them both and attach it to your service charge demands. It avoids an argument later down the line that you've not provided that information. So that concludes my part of the presentation. Thank you.
Thank you, Kate. Peter. So that leads me on to Peter Sibley, who's going to be talking to us about service charge consultation requirements.
Good evening, everyone. I will be speaking for the next 20 minutes or so about when and how statute requires landlords to consult with residential tenants in respect of service charges. I will begin by outlining the key statutory provisions. I will then explore the definition of what engages the consultation requirements, namely qualifying works and qualifying long-term agreements. I will then consider the consultation requirements themselves before looking at the relevant dispensation principles of the need to carry out consultation, and then finally I will conclude. So the key provisions. The key provisions in respect of consultation are sections 19, 20 and 20ZA of the Landlord and Tenant Act 1985 as amended by the Commonhold and Leasehold Reform Act 2002. The key regulations are the Service Charges Consultation Requirements England Regulations 2003 in respect of properties in England. The key takeaway in respect of the consultation requirements is that these provisions provide that if the relevant consultation requirements are not complied with, the contribution of each tenant by way of service charge will be capped at £250 in respect of qualifying works, which will leave the landlord to pick up the tab for the rest, or £100 in respect of qualifying long-term agreements for each service charge year. So they really are quite important, and the consequences of not complying with the consultation requirements can be severe. Section 18 of the Landlord and Tenant Act 1985 defines service charge by reference to relevant costs. In that regard, Section 19 provides in short that relevant costs must be reasonable. To quote the section, it says relevant costs shall be taken into account in determining the amount of a service charge payable for a period only to the extent they are reasonably incurred, and where they are incurred on the provision of services or the carrying out of works, only if the services or works are of a reasonable standard and the amount payable shall be limited accordingly. Now, I mention that because in the Supreme Court decision in Digen Investments Limited and Benson, the Supreme Court, paragraph 52, explained that the purpose of the consultation requirements in Section 20 is to support the purposes identified in Section 19, i.e. to ensure that the relevant costs factored into the determination of a service charge are reasonable in amount. Section 20, as I've outlined already, provides that where this section applies to qualifying works or qualifying long-term agreements, the relevant contributions of each tenant is limited in accordance with this section unless the consultation requirements have either been complied with or dispensation has been granted following a relevant determination by an appropriate tribunal. So turning then to the question of when Section 20, the consultation requirements, when do they apply? The first question to ask is whether you're dealing with qualifying works or a qualifying long-term agreement. Turning to the definition of qualifying works first, this is defined in Section 20ZA subsection 2, and there it provides that qualifying works means works on a building or any other premises. Now that's self-evidently quite a broad definition, and by way of an example of the application of that provision, in Paddington Walk Management Limited and Peabody Trust, it was held that window cleaning did not constitute qualifying works, as, to quote the court, works on a building comprise matters that one would naturally regard as being building works. So cleaning windows, self-evidently not building works. So that's the first stage, is to consider that definition of qualifying works. The next stage is then to consider Section 20 subsection 3, which provides that the consultation requirements will apply to qualifying works if the relevant costs of carrying out the works exceed the appropriate amount. Now, the appropriate amount is presently an amount which results in the relevant contribution of any tenant being more than £250, and that's said in Regulation 6 of the 2003 regulations. So it's important to note there that it's where the relevant contribution of any tenant is more than £250. So that is perhaps easier to satisfy than it may first appear. So once we've considered the definition of qualifying works and the threshold, consideration then needs to be given to whether there is one set or multiple sets of qualifying works. Now, this particular issue was given consideration in Phillips and Francis, which is a decision of the Court of Appeal, and it was held there that for the purposes of the £250 limit in respect of qualifying works, the relevant qualifying works are not the totality of the works carried out by the landlord in the relevant counting period, but those works which form part of a single set of works. So I think in Phillips and Francis it was argued unsuccessfully that the relevant qualifying works were all of those carried out over the course of a year, which was rejected by the court. And at paragraph 36, the court said the following: "It is not an issue that the question of what a single set of works, qualifying works, comprises is one of fact. It is a multifactorial question, the answer to which should be determined in a common sense way, taking into account all relevant circumstances. Relevant factors are likely to include," and I think there are 4. So 1, where the items of work are to be carried out. 2, whether they are the subject of the same contract. 3, whether they are to be done at more or less the same time or at different times. And 4, whether the items of work are different in character from or have no connection with each other. I emphasise this is not intended to be an exhaustive list of factors which are likely to be relevant. Ultimately, it will be a question of fact and degree. So that covers the definition and classification of qualifying works. Turning then to the next definition, which engages the consultation requirements, is qualifying long-term agreements. For the purposes of the next 10 minutes or so, I may refer to them as QLTAs because it rolls off the tongue slightly quicker. So here we start with the definition in Section 20ZA subsection 2, which provides that qualifying long-term agreement means an agreement entered into by or on behalf of the landlord or a superior landlord for a term of more than 12 months. So again, we have a very broad definition under the 1985 Act of qualifying long-term agreements. However, Regulation 3 of the 2003 regulations provides for a series of exceptions to something being a qualifying long-term agreement, and I count there as being 5 exceptions. So the first is that an agreement will not be a qualifying long-term agreement if it is a contract of employment. The second is if it is a management agreement made by a local housing authority. The third is if the parties to the agreement are either a holding company and one or more of its subsidiaries, or 2 or more subsidiaries of the same holding company. 4, where the agreement is entered into and there are no tenants of the building or other premises. and 5 agreements entered into before the coming into force of the 2003 regulations. So that's the first stage, qualifying long-term agreements. Consider the definition in section 20ZA subsection 2 and the exceptions. If that definition has been met, consideration then needs to be given pursuant to section 20 subsection 4, which provides that the consultation requirements will apply to a QLTA if relevant costs incurred under the agreement during a period prescribed by the regulations exceed an appropriate amount. So it's similar to the definition provided in respect of qualifying works. Regulation 4 of the 2003 regulations says that section 20 will apply if if the costs incurred under the agreement in any accounting period exceed an amount which results in the relevant contribution of any tenant in respect of that period being more than £100. And that relevant accounting period is the service charge year. So again, it's any tenant, the contribution of any tenant being more than £100. So then the consultation requirements themselves. What are the relevant consultation requirements? This will depend on a number of things, namely whether the landlord is concerned with qualifying works or a QLTA or both, and also whether public notice is required. What is public notice? Public notice means notice published by the Publications Office of the EU pursuant to the Public Contracts Regulations 2015. And these essentially apply to public bodies. Therefore, the non-public notice provisions in the consultation requirements will generally apply to private landlords. The precise requirements as to consultation are set down in Schedules 1 to 4 of the 2003 regulations. Schedule 1 sets out the consultation requirements in detail in respect of QLTAs where public notice is not required. So Schedule 2 sets out the requirements in respect of QLTAs where public notice is required. Schedule 3 sets out the relevant requirements where there is both a QLTA and qualifying works. Schedule 4 Part 1 sets out the relevant requirements in respect of qualifying works where public notice is required, and then Schedule 4 Part 2 deals with qualifying works where public notice is not required. So you will see from that Schedules 1 and Schedule 4 Part 2 will be the most relevant for private landlords. The requirements are detailed and set out in detail in these schedules, and therefore it's advisable to always consult the schedules themselves and check them thoroughly to ensure compliance. By way of a summary, I will outline the requirements in respect of qualifying works where no public notice is required, perhaps because this is one of the sets of consultation requirements that is encountered most often, and these are provided for under Schedule 4 Part 2. So the first stage in these complying with these requirements is the service by the landlord of a notice of intention. So the landlord must give notice in writing of his intention to carry out qualifying works to each tenant and or to any recognised tenants association. Where I refer to tenant going forward, that includes reference to recognised tenants association. That notice of intention must describe the works proposed or specify the place and hours at which a description of the works may be inspected. The notice of intention must also state the landlord's reasons for considering it necessary to carry out the proposed works. It must also invite the making in writing of observations in respect of the proposed works and specify an address to which such observations may be sent, and that those observations must be made within the relevant period. And the relevant period is prescribed under the regulations, Regulation 2.1, as the period of 30 days beginning with the date of the notice. The notice must also invite each tenant and any recognised tenants association to propose within the relevant period the name of a person from whom the landlord should try to obtain an estimate for the carrying out of the proposed works. So that's the first stage. The second stage is the duty to have regard. So the landlord must have regard to any observations made within the relevant period, within that relevant within that 30-day period. In Wada and Hounslow LBC, the Court of Appeal said the following of the landlord's duty at paragraph 38. The court said, "What this means is that the landlord must conscientiously consider the lessee's observations and give them due weight, depending on the nature and cogency of those observations. In the light of this statutory obligation to consult, it is impossible to say that the tenant's views are ever immaterial. They will have to be considered in every case. This does not, of course, mean that the lessees have any kind of veto over what the landlord does, nor that they are entitled to insist upon the cheapest possible means of fulfilling the landlord's objective. But a duty to consult and to have regard to the lessee's observations entails more than simply telling them what is going to happen." So that's the second stage. The third stage is the landlord must go off and obtain estimates and provide his or her response to observations. So the landlord must go away, obtain estimates for the carrying out of the works, and in the words of the statute, shall try to obtain estimates from those, if any, proposed by the tenants within the relevant 30-day period of the notice of intention. Following that, the landlord shall supply free of charge a statement to each tenant, referred to as a paragraph B statement, setting out the amounts of at least 2 of the estimates obtained and a summary of the observations received during the relevant period and the landlord's responses to them. In addition, where the landlord has obtained an estimate from a person nominated by the tenants, that estimate must be included in the paragraph B statement. At least one of the estimates obtained by the landlord must be from a person wholly unconnected with the landlord. In addition, the landlord must make all of the estimates available for inspection to each tenant, and further to that, the landlord, either in the statement B notice or in a separate written notice, must give written notice to each tenant and any association, specifying the place and hours at which all of the estimates may be inspected, and invite the making of observations in relation to those estimates by the tenants, again within that 30-day period. So it's almost a copy and paste of the earlier part of the process. There's 30 days for the tenants to comment on and provide observations on the estimates obtained. There is then, following that stage, a duty to have regard again by the landlord, and similar principles will apply as discussed on the previous slide. And then there is a duty on entering the contract. Now, this is a conditional duty. It only applies if the landlord does not enter into a contract for the qualifying works with a person proposed by the tenants or the person who submitted the lowest estimate. So if the landlord does either of those two things, there's no need to discharge this duty, but if they don't do that, then within 21 days of entering into the contract, the landlord shall give written notice to each tenant stating reasons for awarding the contract, or specify the place and hours at which a statement of those reasons may be inspected, and the landlord must summarise the observations received on the estimates and provide the landlord's responses to them. So that is a summary of the different stages of the Schedule 4 Part 2 process, qualifying works, no public notice required. Turning then to dispensation. A landlord must either comply with the consultation requirements or obtain dispensation. In respect of dispensation, Section 20 ZA subsection 1 provides, where an application is made to the appropriate tribunal for a determination to dispense with all or any of the consultation requirements in relation to any qualifying works or QLTA, the tribunal may make the determination if satisfied that it is reasonable to dispense with the requirements. So it must be reasonable. The key authority here is the landmark decision of the Supreme Court in Digen Investments Limited and Benson. And helpfully, the upper tribunal has summarised the principles to be extracted from that Supreme Court decision in Jastrzębski and Westminster City Council. And it's paragraph 51, where the tribunal stated the following in summary of the Supreme Court's principles in Digen Investment. And to quote, In determining whether there should be dispensation of consultation requirements, the principles that a tribunal needs to take into account following the decision in Digen Investments are, and I believe there are 5. So 1, whether, and if so to what extent, the tenant would relevantly suffer if an unconditional dispensation was granted. The word relevantly in this context refers to a disadvantage that the tenant would not have suffered if the consultation requirements had been fully complied with, but which they will suffer if an unconditional dispensation were granted. So that's the first principle. The second is the factual burden is on the tenant to identify any relevant prejudice which he claims he would or might have suffered. The third principle is that once the tenant has shown a credible case for prejudice, the tribunal should look to the landlord to rebut it, failing which it should, in the absence of good reason to the contrary, require the landlord to reduce the amount claimed as service charges to compensate the tenants fully for that prejudice. The fourth principle is that it is not sensible or convenient to distinguish between a serious failing and a technical, minor or excusable oversight, save in relation to the prejudice it causes. The gravity of the landlord's failure to comply, the degree of its culpability, the nature of the landlord, and the financial consequences of its failure to comply are not relevant considerations for the tribunal per se. Their relevance will depend upon the prejudice which each such factor causes. So that reiterates the point made in General Principle 1, that prejudice is really what the tribunal is concerned with. The fifth and final principle is that the tribunal could grant dispensation on such terms as it thought fit, providing that they were appropriate in their nature and effect, including terms as to costs. Now, it's important to remember that while these are helpful guidelines, ultimately each case will turn on its own facts when the tribunal is considering reasonableness. To conclude, I have really 3 points that I think it's helpful to remember, and that is that one must always consider whether any works or agreements incurring costs recoverable under the service charge provisions engage the consultation requirements. The second is that if the consultation requirements are engaged, it's very important to refer to the schedules themselves, given the detailed nature of the requirements, to ensure that all of the requirements have been complied with. And third and finally, that dispensation may be granted if the relevant court or tribunal is satisfied that it is reasonable to do so. But in the first instance, it is, of course, the best course to do one's best to comply with the consultation requirements. Dispensation is by no means a dead cert. Thank you very much for listening.
Thank you very much, Peter, for that. And final talk this evening is Admas, who will be talking to you about applications under Section 27A.
Thank you, Myriam, and good evening, everyone. I'm going to be giving an overview of the tribunal's jurisdiction under Section 27A of the 1985 Act. And under that provision, the tribunal has quite a broad discretion, we will see, to determine a range of matters relating to recoverability of service charges in residential leases. And there are technically 2 applications that are allowed for under that provision. And that jurisdiction is part of the statutory framework about other parts of which we've heard about already, that intervenes in private law relations between residential landlords and tenants, and we can say, I think, broadly in favour of the tenant. So in terms of the structure of what I'm going to cover today, I'll deal very briefly with the background section 27A, then I'll set out some preliminary matters, again quite briefly because some of them have already been touched on, particularly by Peter. Then I'll set out what the 2 applications that can be made are, deal with some of the jurisdiction issues that arise, and then I'll make a few practical points about applications in practice and the issue of costs in this jurisdiction. So, as I've briefly mentioned already, the Section 27A provides for jurisdiction of the tribunal to determine 2 applications, whether a service charge is payable and related matters, that's the main one, or the more commonly relied on, and where costs are to be incurred, that is, where they have not been incurred yet, whether a service charge would be payable for those costs and related matters. These applications are determined in England by the first tier tribunal and in Wales by the leasehold valuation tribunals. The jurisdiction, the original form of the jurisdiction was originally introduced by Part 3, Chapter 1 of the Housing Act 1996, within a part entitled Tenants' Rights, which also made provision, for example, for limiting the power of forfeiture on the basis of unpaid service charges. So that gives you a flavour of the policy thinking that was behind the introduction of this particular jurisdiction. In terms of preliminary matters that arise from the statutory framework that are relevant to the application that can be made, as I've noted, it only applies to residential properties, and we find that in the definition of service charge in Section 18 of the 1985 Act, and the definitions set out there, and Peter touched on the definition of relevant costs, which are the costs or estimated costs incurred or to be incurred in connection with matters for which the service charge is payable. The second preliminary matter is the statutory limit placed on recoverability of service charges in this context by Section 19 of the 1985 Act, which in substance imposes 3 further requirements as a threshold for recoverability of service charges. So relevant costs should be taken into account in determining the amount of a service charge payable only to the extent that they are reasonably incurred and the amount payable is accordingly limited. Where they are incurred on the provision of services or the carrying out of works, only if the services or works are of a reasonable standard and the amount payable shall be limited accordingly. And thirdly, where a service charge is payable before the relevant costs are incurred, no greater amount than is reasonable is so payable. So we have 3 essentially further requirements that are imposed on the service charge arising as a matter of private law, and the effect of that recoverability provision was summarised by Lord Justice Lewison as overlaying the lessee's contractual liability by the imposition of a cap in those 3 ways that that I've just highlighted. In terms of the approach that's taken to reasonableness when this arises in the tribunal, the guidance is that reasonableness should be read in its general sense and given a broad, common sense meaning. A distinction is drawn between what is reasonable and what is reasonably incurred. The latter requires asking whether the action taken in incurring the costs was reasonable and the amount of those costs was reasonable. A regard will be had to the terms of the lease, and the reasonableness of the demand is to be assessed by what is known at the time the tenant's liability arises. So that's a general approach that's taken to reasonableness, which becomes relevant because of the statutory limits on recoverability. And that essentially is the backdrop for the main subject matter of the talk, which is the applications that can be made under Section 27A of the 1985 Act. So there are 2 applications, and the first and more common application is under subsection 1, which provides that an application may be made for a determination of whether a service charge is payable, and if it is, as to the person by whom it is payable, the person to whom it is payable, the amount, date at which it is payable, and the manner in which it is payable. And this applies whether or not any payment has been made, but if you recall, the definition of a service charge in Section 18 is based on the it being payable, but not necessarily whether or not it has actually been paid, as is made clear by subsection 2. So that's the first application under subsection 1. Under subsection 3, the other application that can be made is for a determination whether, if costs were incurred for services, and that is to be read as if costs were to be incurred for services, repairs, maintenance, improvements, insurance, etc., a service charge would be payable for the costs, and if it would, similar related matters. And that's essentially a parallel jurisdiction to determine whether, if costs which were to be incurred but which have yet to be incurred were incurred, would a service charge be payable for those costs. And in both respects, the tribunal was exercising essentially a declaratory jurisdiction. It's going to, the outcome will be a declaratory as to whether the service charge is or would be payable. Just a few points on jurisdiction issues that arise in this context before moving on to more practical matters. As a starting point, of course, we're dealing here with a statutory tribunal, and so the extent of jurisdiction is a question of statutory interpretation of the relevant provisions. There's no such thing as an inherent power to do anything or to determine any question. Section 27A makes it makes the point expressly that the tribunal's jurisdiction is in addition to that of any court, and that no application may be made under subsection 1 or subsection 3 in respect of a matter that has been the subject of determination by a court already. Furthermore, no application may be made in respect of a matter which has been agreed or admitted by the tenant. However, the tenant is not to be taken to have agreed or admitted any matter by reason only of having made any payment. That's expressly provided for in subsection 5. And an agreement that purports to provide for determination in a particular manner or to limit the evidence of any question which may be the subject of an application under subsection 1 or 3 is void. So the statute imposes quite severe restrictions on the extent to which the agreement can oust essentially the tribunal's jurisdiction. And we have an example of that in the relatively recent Court of Appeal decision in Aviva Investors, Ground GP Limited in Williams, which considered a lease under which service charge was calculated on the basis of a fixed percentage of certain categories of costs, or such part as the landlord may otherwise reasonably determine. So on the face of it, the landlord could modify those percentages essentially. And the Court of Appeal held that the effect of the exclusion of the agreements mentioned a moment ago under subsection 6 meant that this agreement ought to be seen, in light of that provision, as an agreement as to the particular manner in which the amount of service charge is to be determined, because it made provision for the landlord themselves to reasonably determine the amount of the service charge. And so subsection 6 was engaged, and the effect of subsection 6 is that the landlord must be deprived of their role in making that determination. You could leave everything else in place in that clause, but you had to take the landlord's unilateral ability to determine the service charge amount out of the picture. You had to read it out. And so what the court said is that the lease should be read as if it had provided for the fixed percentage or such part as ... insert entity may otherwise reasonably determine. And on that reading, the ... is to be filled in by the first tier tribunal. So it steps in, and then it's open to the tenant or the landlord to make an application. So that's an example of how that jurisdictional clause in subsection 6 operates in terms of construing provisions of that kind. In terms of arbitration agreements specifically, previously disputes covered by arbitration agreements were excluded from the tribunal's jurisdiction, but as of 2004, following the amended version of the provision introduced by the 2002 Act, only an arbitration agreement that is entered into after a particular dispute has arisen excludes the tribunal's jurisdiction. And all other arbitration agreements essentially fall within the preclusion of agreements which attempt to oust the tribunal's jurisdiction, and they don't affect the tribunal's jurisdiction. So moving on to 27A applications in practice, the application is made by filling out and submitting Form Leasehold 3, which is available online, and there's a fee of £100 for making the application, £200 on notice of hearing date. On receipt, the applicant sent an acknowledgement, and the respondent and any persons significantly affected by the application will be served by the tribunal. The tribunal, once it has received the application, will make some case management type decisions. It will decide whether to deal with the case on the papers or by a hearing, first of all. And then if it does decide to deal with the case by a hearing, it will allocate it to a fast track or a standard track. The fast track is limited to cases that the guidance describes as very simple and that will not generate a significant amount of paperwork or argument. But in the main, cases will be allocated as standard track, which is all other cases, essentially. In most cases, the tribunal will order a case management conference in standard track situations where directions will be made in the normal way, and there will be an attempt to identify areas of agreement and to narrow the issues between the parties. Normally, directions will provide for statements of case, followed by disclosure and witness statements, and with a direction for Scott schedules not uncommon. There's quite a bit of variation in practice and procedure, and it's important to note the ability to make an application for the tribunal to make directions under Rule 6, particularly where a party feels that the tribunal has omitted to order to make some direction that is actually important for managing the case in a proper way. And it's perhaps helpful here to just touch on some of the differences between an application in the tribunal and an application or a claim in a more formal court setting. It is, of course, a more informal environment. There's less of a focus on procedural rules, particularly as to admissibility of evidence. There's a significant proportion of litigants in person who are involved in these matters, and so distinctions between making submissions and giving evidence can be perceived as less important. And furthermore, the tribunal, by virtue of its composition and its function, will see itself as having a more inquisitorial role in terms of its ability to inquire into the issues and to draw on its own expert background, although that is a fine line for the tribunal to navigate at times. The burden is technically on the landlord to establish reasonableness, because it will be the landlord who invariably is seeking to enforce the service charge. In practice, the tenant has to provide some evidence of unreasonableness, at least as a starting point, and that's an extract from a judgment of Judge Elizabeth Cook there, which makes that point. In terms of the kind of evidence that one would tend to see, typically where you have a tenant who's attempting to challenge the reasonableness of a service charge, one would expect, or one would hope, that they would provide evidence of alternative estimates, some alternative factual basis for the tribunal that would allow the tribunal to assess reasonableness of the service charge in question. From the perspective of a landlord who's seeking to justify a service charge, the kind of evidence one would see or expect or hope to see would be copies of service charge demands, accounts, contracts, management contracts, insurance estimates, policies, and so forth. So moving on to costs and the costs jurisdiction. In general, it's a no costs jurisdiction, so the ordinary rule that the winner pays the loser's costs does not apply. As we've already seen, we're speaking of a statutory tribunal, so we look at statute to work out what it can and cannot do, and the rules make it clear that the first tier tribunal can only make a costs order, so far as is relevant for these kinds of applications, for unreasonable conduct or wasted costs. And another situation where costs arise is where statute or contract, most relevantly the lease, specifically provide for a certain costs liability, normally on the tenant. In terms of contractual costs, where the lease makes provision, the tribunal has two relevant powers to limit the ability, essentially, of the landlord to recover costs via the service charge and via an administrative charge. So just looking at those briefly, because they do come up very often in these applications. So in terms of recovering costs under the service charge, Section 20C of the 1985 Act grants the tribunal power to order that costs of proceedings incurred or to be incurred should be disregarded in determining the amount of the service charge payable by the tenant. And the form Leasehold 3 that one fills out when making an application includes a box asking whether such an application is sought, and such applications are commonly sought. And there's an extract there from a decision of the Court of Appeal in Hyperion Investments, where the court crystallises the point, or one of the points of Section 20C, as being to deal with cases where the tenant's been successful in litigation, but the landlord is nevertheless able to rely on a contractual cost provision. So the landlord should not be able to get through the back door what they've been refused by the front, is the way it's put. So that's costs under a service charge. The other relevant statutory provisions, the other relevant category of contractual costs that are dealt with is under administrative charges, which are in essence costs paid by a tenant individually. There's a more precise definition in paragraph 1 of Schedule 11 to the 2002 Act. And so the relevant statutory power there is found in paragraph 5A of Schedule 11 to the 2002 Act, and it provides a very wide discretion to inter alia the tribunal to reduce or extinguish an administration charge. So the tenant may apply to the tribunal for an order reducing or extinguishing its ability to pay a particular charge in respect of litigation costs, which are defined as costs incurred or to be incurred by the landlord in connection with proceedings, including proceedings in a first-tier tribunal. And the tribunal may make whatever order on the application it considers to be just and equitable. So very broad, very wide discretion. Tribunal is likely to look at the outcome, the conduct of the landlord, and some further hints of the kind of matters it might look at was given by the upper tribunal in the Avon Ground Rents case. The proportion of legal costs in relation to the amount of the sums in dispute and to the issues involved and to the level of representation appropriate. Essentially, proportionality of costs questions are likely to be relevant. So that's costs, and that's the last stop in the whistle-stop tour of the Section 27A jurisdiction. So the key points: the applications comprise a significant proportion of disputes in the tribunal. The application is made by form Leasehold 3, available online. The tribunal has a broad discretion to determine a range of matters relating to recoverability of service charges in residential leases under subsection 1, whether service charge is payable and related matters, so the question of construction of the lease and also the application of the statutory limitations on service charge, and whether service charge is payable for costs that are to be incurred. So that's costs that have not yet been incurred under subsection 3. The tribunal's jurisdiction is very broad, and the landlord is unlikely to be able to retain a unilateral discretion as to the service charge amount. That's taken from the Aviva case. I should note that that case is on appeal to the Supreme Court, so stay tuned as to the outcome of that. So in terms of the tribunal's approach to what is reasonable, it's a broad common sense discretion. In practice, the tenant has to provide some evidence of unreasonableness, and in general, this is a no-costs jurisdiction, and we've looked at some of the details of that already. Thank you very much.
We are now at the phase of tonight where we can ask and deal with some questions that are coming in from the audience, both in the room and online. We've got a mic in the room, and there are a number of questions that have already been submitted via the online platform. As those questions continue to come in, I don't know whether anyone in the room has got a question that they want to ask. Yeah. Thank you.
It's just whether or not Section 48 notices are also suspensory by nature, and whether they can also, because also I note that they are to suspend enforcement, so you're not meant to be able to take enforcement until a notice has been served. So, are they suspensory, basically?
That's one for you, I think, Kate. Can they be made good retrospectively?
So they are similarly suspensory in nature. You would have to put the information in at a later date. As with the demands, if, for example, the landlord sent a demand and didn't include the landlord's address or didn't include a piece of information under Section 48, if they send that within the 18-month period and go, oh no, I've done this wrong, how do I fix it? If they then send another demand complying with Section 47 and 48, then that would then validate the demand. Similarly, that can be done, for example, if you instruct solicitors and they send a letter before action and then send that information, it can be done then, and they can cure any non-compliance with Section 47, Section 48, and with the obligations that need to be appended to as well. So it can be cured later on the line.
Thank you, Kate. In relation to 48, there's actually another question that's come in, which is, can the address for service notified under Section 48 be a managing agent's address as opposed to the landlord's address?
So that comes to me.
Is that?
So there's an important distinction to make between Section 47 and Section 48. So Section 47 specifically requires the landlord's name and address to be included, whereas Section 48 doesn't make that specific provision. So you could put it as a managing agent's address, provided they are based in England and Wales. And that's where the difficulty then comes in, when people don't say this is the landlord and this is the managing agent, and don't draw a distinction between the two of them. What I found in practice is a good way of dealing with that, is highlighting what is required under Section 47 by a sort of sub-tab, the information underneath saying this is the landlord, this is where you serve this information. Similarly, subheading Section 48, this is the address for service of any proceedings in England and Wales, and provide that address, and that makes it very clear who is who and what information you need to provide. If you don't have a management agent, then it would be your landlord's registered business address in England and Wales that you'd provide for the Section 48 compliance.
Thank you. Whilst you're thinking possibly of asking some questions, what one about consultations, perhaps possibly one for Peter. So in terms of what qualifies as a what did you call it, QLTA?
Yes.
Qualifying long-term agreement. Would a 6-month agreement followed by a rolling agreement for however long qualify, or would that be excluded?
I think that would be excluded, and there is, I can't remember the name of the authority off the top of my head, unfortunately, but that particular issue was a subject of some authority, and I think it says that the agreement must be of a fixed term of more than 12 months in order for the QLTA definition to apply to it. So 6 months followed by a rolling term thereafter would not satisfy the QLTA definition. Sorry, I can't remember the name of it.
No, not at all. So fixed term is the key. Okay, yes. And in terms of commercial premises, are there any similar statutory consultation requirements, or is this simply to do with residential?
No, so the consultation requirements I referred to are only relevant for residential property. There is some guidance, I think, in a RICS guidance document on commercial premises, and that it's good practice to consult on qualifying works or QLTAs, but it's not binding. It's just good practice. Yeah.
Does anyone else in the room have any questions?
Hello everyone. Do these requirements apply if there's a management company set up and owned by the tenant? So if it's a tripartite lease, the responsibility for the service charge obligations is on the tenants rather than the landlord? and then you have no reversionary interest, would you still have to comply with the consultation requirements?
So, I mean, the consultation requirements apply to the landlord under the 2003 regulations and under the Landlord-Tenant Act. So, sorry, your question is about where the tenants...
Yeah, so in some leases they'll be tripartite, so you'll have the landlord who will just have quiet enjoyment and insurance, and then the repairing obligations will be on a management company, which will be collectively owned by the tenants. I'm just wondering, would that management company or director of the management company have to comply with the obligations?
Well, they're not the landlord. I mean, I can't... the requirements under statute and the 2003 regulations are on the landlord, and I can't see that you can't define a tenants association in that situation as a landlord.
And would that apply for a Section 27 application as well, then, perhaps?
So I'm not. This is a tripartite situation. The landlord has the quiet enjoyment or more limited obligations, and then.
Yeah, and then the service charge is usually looked after by the management company.
So the management company takes the position of the landlord in relation to the service charge. So it seems to me that the same process would apply.
Yeah, okay, right, thank you.
Otherwise, it would seem like a way in which to sidestep the statutory obligations by a kind of structural mechanism.
Yeah, the fact that they own the company, it's incorporated, isn't it? So you'll have independent, separate legal personality. The fact that they own it shouldn't affect that unless there's some specific provision, which I'm not aware that makes specific.
Moving to dispensation is quite an important area, isn't it? Because if you get things wrong, then you might face an application, your objections, and then a landlord would have to apply for dispensation. Can you help us with what kind of facts, what's the type of prejudice that might justify a refusal of dispensation? Because I think that the test is that the burden's on the tenant to prove that their position is prejudiced. What might that look like in terms of the factual position?
I think the clearest example of that would be if the tenant could show, if you'd consulted me properly, I would have been able to ask you to get an estimate from this contractor. And if the tenant can provide evidence that that contractor would have done the work for this amount of money, then you would quite clearly be able to show what extra money has been spent as a result of a failure to comply. So that's sort of a fairly clear instance of prejudice. That would be
so tangible financial difference.
Yeah.
I did have a case just before Christmas where a similar issue arose, and the tenant essentially said, by your failure to consult me on this, these costs have sort of rapidly increased from a lower amount to, I think it was like 5 times what it was. And the tribunal said, well, there's a clear prejudice. Had you gone through this process and consulted, potentially these costs wouldn't have gone up as much as what they have gone up. You've also acted unreasonably by failing to notify them of the cost increasing in any event. So in that situation, it was a clear, tangible loss to them, and they were successful on that element of their application.
Thank you. Back to your question. Somebody helpfully said online that Section 30 gives the definition of landlord a broad meaning, anyone entitled to enforce an obligation. So that, I think, covers it. Right. Any other questions in the room? Yes, please.
Thank you. I've got a question from the other way round, really. What can a residential leaseholder do if the landlord and managing agents are not carrying out maintenance and repairs, and these are clearly due?
So this is to do with the obligation on the landlord to do the works. Yes. This is not you're asking me to pay for something. It's more you haven't done the thing.
Where the leaseholder is prejudiced by the landlord not carrying out works.
Yeah, and being asked to pay more as a result of neglect.
No, and being asked to pay nothing, but if the leaseholder wants to preserve their flat and the building, and say, I've got a few cases of leaking roof terraces or corroded water tanks, and the managing agents and landlords are just doing nothing.
Yeah. Well, that's not so much a service charge issue. That's more a landlord and tenant look at the covenants and specific performance type issue. So I think what you do there, that wouldn't be a matter for the tribunal, it'd be a matter for the court. And you'd bring a claim if you're requiring works to be done before the court, and the court's got jurisdiction to grant an order for specific performance. So you'd bring an ordinary claim, citing the obligation and setting out the facts. which justify you saying they haven't been complied with. So it's breach of repairing obligation claim, in short. Yeah. But there is a question about neglect, because where a landlord hasn't done what it was supposed to do, a defence that's often raised by tenants will be that, oh, well, I'm actually being asked to pay more than I would have had to pay had you done your job. Is that something that you guys have come across? And if so, does the tribunal have jurisdiction to deal with it?
So I found a lot of the time tenants, particularly when they're acting as litigants in person, will suggest that there's an issue of historic neglect. So you have failed to undertake repair works to X, Y, and Z, and by reason of that and a delay, my service charges and the works are now considerably more than what they should be. That's not a question in and of itself as to whether the service charges are reasonable. It's still a question as to has there been a breach of the repairing covenant. The FTT does have jurisdiction to deal with that, but more often than not won't deal with it and will say it needs to be a point considered by the court, or will completely ignore it and say you have to bring it as separate proceedings, as I've recently had in another claim, because they can be quite complicated, particularly if you've had different landlords over a different period, because it's who does that liability vest with. So it can be dealt with in short, but it's normally not dealt with in the tribunal, in my experience.
So people are asking a lot about questions about dispensation. Who normally makes an application for dispensation? Would it be solicitors representing landlords, managing agents, or landlords themselves, or can it be any of the above?
Well, I think it's
a practical question, I think.
I think it's probably the landlord as defined in Section 30. Mm-hmm. And a solicitor acting on behalf of a landlord can presumably make an application on the landlord's behalf. And I think that the standard form to be used in Section 20 dispensation applications does provide for the ability of the managing agent to apply as well. So I think it is perhaps all of the above, provided they're acting for a landlord.
A representative or agent, yeah. Okay. Kate, you talked about Section 20B in terms of time limits in respect of demands. Can you help us with the time? When does time start for the purposes of costs being incurred, and when does time stop, so that we can be clear about how that period's calculated?
So in terms of this, is actually an issue that there was a lot of ambiguity about when costs were incurred, and it was first considered in a case of Bear and OM Property Management Limited back in 2013, and that case did not assist at all in the ambiguity. Essentially it said, one, it's when a demand for payment has been made, or two, when the landlord company makes payment, so it left it quite open-ended. It was then clarified in the upper tribunal in a case of Ground Rents and Regis Port Limited and Dowden, and essentially the upper tribunal preferred the date that when you're provided with the invoice from the supplier. So if, for example, you have gas, electricity, or you have a contract to provide specific services, when they send you the demand for payment, that's cost incurred at that point, and the 18 months starts to run. The 18 months stops when the costs incurred are demanded from the tenant by valid service charge demands that comply contractually with the provisions that specifically request payment of money. So it's not just informative information saying at some point you might incur this, it's this is due and this is when it's due. And it has to be a demand for an actual expense rather than a mere estimate. So that's when it stops running, when that demand goes out.
Yeah, thank you. Yes.
Thank you. I've got a question about reasonableness of service charge demands. So what would be the case when what would be generally reasonable conflicts with what I've got in a lease? So, for example, if some tenants covenanted to pay service charges for certain works, but a part of them actually carried out the works themselves, it would be contractually correct to ask them to pay for the total of service charges, but it wouldn't be reasonable because they carried out the works alone.
So, sorry, the lease provides for a mechanism as to how the work should be carried out?
No, the lease provides that everyone should pay service charges for a certain work.
Right.
But some tenants carried out that works for their demise premises autonomously.
Yeah.
So now when a landlord wants to carry out the works for the entirety of the building, like, it would be contractually correct to ask those tenants to pay for the entirety of the works, but it wouldn't be very reasonable as a matter of fact.
Because the tenants have already incurred the cost.
Yeah, because they've already paid for themselves.
Unilaterally.
So what happens when reasonableness conflicts with our contractual provision? That's my question.
Admas, do you want to take that one?
I don't know what Kate would say on that, but it seems to me that reasonableness, you'd look at, you'd take a step back to look at reasonableness. You wouldn't do it on that kind of individual by individual basis. You're looking at the nature of the service charge obligation as a whole, and you're also taking account of factors such as practicability. So the practicability of the landlord organising the works in a way that allows for case-by-case exemptions, because someone has gone off and done something, I assume, without telling the landlord. Those things seem to me to feed into reasonableness.
I agree with that. I mean, otherwise, what your situation seems to be a tenant kind of going in and ultimately trying to undo the mechanism that's been agreed in the lease. And why should the landlord have to be burdened by that decision having been taken?
I mean, you'd look at that and think, on one part, your tenant's being quite unreasonable in doing the works themselves if the landlord has set down that they're going to do the work. So I think it'd be quite fact-specific, but you would revert to your contractual provisions and see what's been said, and the assessment of reasonableness would follow. If your tenants had an agreement with the landlord that they could do the works and not incur it for the service charge, and the landlord demands it from the service charge, that may be a different question. I think it's a very fact-specific situation that you'd have to look at the lease itself and take a step back, look and see how this situation has arisen before you could say one way or another.
Yeah. Thank you. Got a question about the figures. So the figures, Peter, that you referenced in relation to qualifying works, 250 and 100, depending on what you're looking at.
Yeah.
Are those charges per year or per month?
So I think I'm right in saying that the £250 in respect of qualifying works is just the amount that a tenant has to contribute to those works. So it's not necessarily time period specific, it's tied to the works in question, and provided that you've got a separate set of works. And I think it was the Phillips case that I referred to, where you need to look at individual sets of works rather than all the works that have been carried out over the service charge period. But in respect of QLTAs, the £100 is what the tenant has to contribute in respect of that QLTA for a year. So I think in respect of QLTAs, it is partly tied to the accounting service charge year, and the expenditure has to be more than £100 for each tenant in respect of that QLTA per year.
Thank you. And on a connected note, in terms of dispensation applications, is there a time period for applications for dispensation? So, for example, a landlord hasn't complied, urgent works have been carried out. Do they need to make it good by making an application for dispensation before the urgent works go, or after, or is there a time period? Is what somebody here is asking. Yeah,
I'm not entirely sure. I'm not aware of a specific requirement or specific time period in the rules themselves. I think it's a factor the court will take into account in assessing reasonableness, as to whether it's reasonable to dispense. If you've left it a long time, then perhaps that's something the court will weigh in to the balance.
I mean,
the tribunal, sorry.
I have made an application for dispensation in the face of the tribunal there and then. So I don't think there is, and that was for something that had happened quite a long time. So they can be quite flexible with it.
How long ago can you recall? How much?
I think the works were about 3 years before.
Oh, really?
So, I mean, it wasn't a very good argument, but it was still one that I was instructed to make.
Did you succeed?
No. But I still made it.
Good. Okay. Anyone else in the room?
If you have issued a Section 20 notice without attaching a summary of rights, the 18-month period has passed. Is it still possible to then backdate by giving a summary of rights and then recover those service charges, even though it's longer than the 18-month period?
So, in terms of if you've put the demand in and everything else is valid on the demand within that 18-month period, but you've just not attached the summary of...
Yeah, exactly.
Yes, and it's been cured in practice by letters before action when they've been issued. And there is a case which I anticipated potentially someone might ask this question, which does set out... So the case that you would want to look is called Tudor Roberts and Countryside Residential, where it actually said that failure to attach it, errors in font size, paragraph numbering, and even the order in which something was structured could be cured by way of providing it with the letter before action, and the demand hadn't been accompanied in that situation by the summary of rights. So it can be cured retrospectively, but it would still sort of be about, you know, making sure that there was something within that 18-month period to validate it.
Thank you.
I think we've got time for one more. And in the absence of anything from the room, I'm going to ask this question. I'm taking a bit of a flyer, so we'll see whether we've got some responses. It's a combination of a consultation question and a reasonableness question. So if a council serves a Section 20 under a QTLA, qualifying long-term agreement, for a £4 million roof, and the tenant makes observations, but the council ignores and still appoints the contract, the question is, does Section 27A protect the tenant's right to make a reasonableness application? So in other words, can the tenant still argue or challenge reasonableness? Any views? So it's the interrelation between you've consulted and the landlord's taken the decision to proceed, and does the tenant then still have the ability to challenge costs through Section 27A?
So you've had your consultation requirements, and they say, actually, I still think this is unreasonable. I mean, I've seen people do it. It's not worked out very well for them in doing it, but that's normally because of other issues. Tends to be with their applications. If they've complied with the requirements, then I think you'd struggle having an uphill battle in terms of challenging the reasonableness of it, unless you can demonstrate that there is something that they've gone wrong in procedural process.
The whole purpose of the consultation requirements is that you're going through and you're subjecting the very works that you're carrying out to scrutiny and giving the opportunity, having regard to the observations, and then making a decision following that process. So, but that question, I think, demonstrates, in some of the blank faces, that this area is extremely tricky. As I said before, lots of tripwires. Landlords need to look out for, and tenants need to have a good grasp of. So I'll just want to end, following that very informative session with a lot of detail, to say two big thank yous. First of all, thank you to you all for attending, both in the room and online, and showing so much interest and for your interesting questions. And also thank you to our speakers for their detailed talks and their diligence in preparing all of this, which isn't easy. It takes a lot of time, and it's been extremely helpful. So if we can put our hands together and thank them.